Good afternoon, everyone, and welcome. My name is Amanda Van Schaik, Financial Advisor, CUSO Financial Services at Wright-Patt Credit Union. In this estate planning presentation, we'll take a look at some general estate planning concepts and strategies. And while there's no such thing as a one-size-fits-all estate plan, this overview may assist you in thinking about your own estate planning needs and may help you in determining whether you might benefit from working with a financial planning professional. What is an estate plan? Simply put, it's a map of how you want your personal and financial affairs to be handled in case of incapacity or death, and the subsequent implementation of the strategies that will fulfill those objectives. Who needs an estate plan? Chances are you do. You may think that estate planning is just for the wealthy, but it's not. In fact, an estate plan may actually be more important if you have a smaller estate because your final expenses will have a much greater impact on your estate. And there's a much greater possibility that your loved ones could suffer from a lack of financial resources. The fact is, without an estate plan, you can't control what happens to your property if you die or become incapacitated. Generally, people create estate plans because they want that control. They also want to make sure that their wishes are clear in order to avoid family disputes. In addition, they care about preserving their property for their loved ones and want to make sure that their loved ones are properly provided for. An estate plan is especially important if your spouse isn't comfortable with financial matters. You have young children who would need a guardian. You have an estate that will be impacted by transfer taxes. In 2021, on the federal level, that generally means estates that are over 11,700,000. So let's go into more detail about that. We'll go into more detail about that later. Also, be aware that this amount may be lower on the state level. States impose their own transfer taxes, and each state has a different exemption amount. Estate planning is also particularly important if you own property in more than one state, you have privacy concerns, or you have other distinct needs, for example, planning for the succession of a business. These are the estate planning concepts we'll be looking at today. We'll talk about planning for incapacity first, briefly discussing both healthcare issues and property management issues. Then we're going to talk about planning for death, focusing on wills and probate, tax basics, lifetime gifting, trusts, and the role of life insurance in estate planning. Incapacity describes the condition in which you are legally unable to make your own decisions. We're talking about planning for incapacity first because incapacity could happen to anyone at any time. Think for a moment what might happen if, for example, you were to become the victim of an accident that puts you in a coma for several months. How would your doctor know what medical treatments you would or would not want if you can't speak for yourself? How would your personal business be transacted if no one is authorized to sign documents for you? What would happen is this: someone would have to go to court and get a legal permission to do things for you. And that person, who's called a guardian and is usually a close family member, such as a spouse or a child, would have to go back to the court every time permission is needed. So, as you can imagine, this might be quite burdensome to the guardian. Further, without any prepared instructions from you, your guardian might make decisions that you would be different from what you would have decided. So let's talk about healthcare directives first. You can leave instructions about the medical care you would want if conditions were such that you couldn't express your own wishes. There are three different ways to do this: with a living will, a durable power of attorney for healthcare, which is referred to as a healthcare proxy in some states, and a do not resuscitate order or DNR. A living will is a document that lists the types of medical treatment you would want or not want under particular circumstances. For example, your living will might state that you would not want life support if you fell into a persistent vegetative state. With a living will, you'll have to think about all possible scenarios where you would want a specific action to be taken, and then put your wishes in writing so that the reader will clearly understand them. A durable power of attorney for healthcare or healthcare proxy lets one or more family members or other trusted individuals who are called agents make medical care decisions for you. Unlike a living will, this type of healthcare directive, you don't have to envision specific circumstances. You simply grant authority to your agent or agents to make decisions for you. A do not resuscitate order is used for a different purpose. Let's say that you're in the hospital, lingering and suffering with a terminal illness, and you don't want the hospital staff to take life saving measures if you suddenly go into cardiac or respiratory arrest. To make sure your wishes are carried out, you may want to get your doctor to issue a DNR. A DNR is a legal form signed by both you and your doctor that's supposed to be by your bed to give staff members the permission that they need to carry out your wishes. When using a DNR, some states require their own form, and some states require one DNR form that if you're in the hospital and different from when you're in a nursing home. Be aware also, sorry about that. Be aware also that some states don't recognize some of these healthcare directives. So depending on your state, you might need one, two, or all three of them. Now let's take a look at some property management tools. There are three ways you can plan to have your financial affairs taken care of for you in the event you become incapacitated. You can arrange to own property jointly, appoint an agent using a durable power of attorney, or create and put property in a living trust and name someone to take over the management of the trust if something happens to you. Granting joint ownership of your property to another person allows that person to have the same access to the property as you do. If you become incapacitated, your joint owner simply acts instead. For example, if you and your spouse have a joint checking account, each of you can make deposits and write checks. So if you were to go into a coma, your spouse would also still be able to make the mortgage payments on time. A durable power of attorney lets you name family members or other trusted individuals to make financial decisions or transact business on your behalf, just like with the durable power of attorney for healthcare. In addition to joint ownership and a durable power of attorney, using a living will is another common strategy. We'll talk in more detail about trusts later, but for now, just know that a living trust can be used in planning for incapacity, because someone called a successor trustee can step into your shoes to manage the property in the trust if something should happen to you. All of us make plans that are based on the possibility that a specific event may occur. Many of us carry more than the minimum required amount of auto insurance because we recognize the possibility that financial loss could result from an accident. Since it is 100% certain that each of us is going to die at some point, you might think that everyone would have an estate plan. The fact is, though, that's just not the case. So, what happens if you die with no estate plan? If you own property jointly, that property may pass automatically to your joint owner upon your death. If you have an IRA or retirement plan, or you own life insurance, funds will pass automatically to your designated beneficiaries when you die. Similarly, property held in a trust may pass automatically to a designated beneficiary. And in general, however, property will pass according to state intestacy laws. These laws govern the disposition of property when someone dies without a will or with a will that doesn't account for a portion of his or her estate. Let's say you die leaving 5,000 in a savings account. Who does the money go to? Without instructions from you, the money would go to the person or people that your state's intestacy laws say it should go to. Intestacy laws and vary from state to state, but here you see a typical pattern of distribution. 50% of the property goes to the spouse and 50% to the children. Remember, it is maybe different in your state. The biggest issue with intestacy is the fact that your actual wishes are irrelevant. Let's assume that you live in a state that has intestacy laws patterned to show what we have here on this slide. Without an estate plan, regardless of your actual wishes, for example, let's say you wanted all of your property to go to your spouse and none to your children, your estate would be divided between your spouse and your children. There are many potential problems with allowing your property to pass by intestacy. For example, the distribution pattern imposed by your state's intestacy laws could result in disputes amongst your heirs and higher overall taxes due. Intestacy can be particularly problematic for unmarried couples since intestacy laws generally will not include an unmarried partner in the distribution of property. There's a very simple way to avoid this, though. You can create a will. A will is probably the most vital piece of anyone's estate plan. A will is a legal document in which you direct how your property will be dispersed when you die. It also allows you to name an executor who will carry out your wishes, which are stated in your will. In addition, your will lets you name a guardian for your minor children. And you can also create a trust in your will. You can use your will to accomplish other estate planning goals as well, such as tax planning. To be valid, your will must be in writing and signed by you. Your signature must also be witnessed, although the number of witnesses required vary from state to state. And these requirements are important because if you aren't careful, your will may be invalid. So, see an estate planning attorney to take care of this for you and avoid any do it yourself solutions. Now, there is one big consideration to having a will for some people, and that's the fact that wills generally have to go through a process known as probate. So, we'll take a look at the probate process next. Most wills have to be probated. The rules vary from state to state, but in some states, smaller estates are exempt from probate or qualify for an expedited process. So, what does probate entail? Probate starts with someone filing the will with the probate court, which will then oversee the estate settlement process. Usually, the person named as the executor in the will does this. Once the will is filed with the court and validated, the executor can go about the business of settling the estate. This means collecting monies owed to the person who died, such as wages, paying any outstanding bills, filing final income tax and estate tax returns, if necessary, and then distributing the remaining property to the rightful heirs. Usually, everything goes smoothly during the probate process, which typically lasts anywhere from a few months to a year, depending on the size of the estate. As long as the executor does what needs to be done in a timely fashion and there are no family squabbles. Nevertheless, some people may want to avoid this process, so let's take a look at why this is so. Before we look at the reasons why you might want to avoid probate, let's review the possible positive aspects of probate. For most estates, there's usually little reason to avoid probate. The actual time and costs involved are modest, and it doesn't make sense to plan around it. And there are actually a couple of benefits from probate. Because the court supervises the process, you have some assurance that your wishes will be abided by, and if a family squabble should arise, the court can help settle the matter. Further, probate offers some protection against creditors. As part of the probate process, creditors are notified to make their claims against the estate in a timely manner. If they do not, it becomes much more difficult for them to make their claims later. But for some complex estates, probate can be more burdensome, taking up to 2 or more years to complete. This could tie up property that your family may need immediately and also increase the costs that can arise, such as executor fees, attorney fees, and insurance costs. And if you have real estate in more than one state, for example, and you own a summer home in Maine and a winter home in Florida, your executor will have to file in each state where the property is located. This is referred to as ancillary probate. Additionally, wills and any other documents submitted for probate become part of public record, which may be undesirable if you or your family members have privacy concerns. If any of these issues are a concern to you, an estate plan can be designed to limit the assets that pass through probate or to avoid probate altogether. The major ways property is passed out of probate are by owning property jointly with rights of survivorship, by ensuring that beneficiary designation forms are completed for those type of assets that allow them, such as IRAs, retirement plans, and life insurance, by putting property in a trust, and by making lifetime gifts. Now, let's switch gears a little and talk about estate taxes. There are three types of federal taxes that may be imposed when property is transferred from one person to another, either during life or at death, referred to collectively as transfer taxes. These taxes are the gift tax, the estate tax, and the generation skipping transfer tax. We're going to discuss transfer taxes on the federal level only, but be aware that the individual states may also impose their own transfer taxes, and they generally affect smaller states. It's important for you to get more information on the transfer taxes imposed by your particular state. If you, the donor, transfer property to another person, the donee, during life, the transfer may be subject to gift tax. The reason there's a gift tax is to prevent individuals from avoiding the estate tax by giving all of their property away before they die. The gift tax doesn't apply to every lifetime gift, though. For example, in 2021, you can give up to $15,000 to as many individuals as you want gift tax free under the annual gift tax exclusion. By the way, that figure for $15,000 is for 2021, but the annual gift tax exclusion is indexed for inflation, so it may change in future years. In addition, each individual has a lifetime exclusion from all transfers, that's gifts and your estate combined, that is 11,700,000. That's the largest exclusion that's ever been allowed in the history of the federal gift and estate tax. When property is transferred at death, it is generally subject to estate tax. This is true whether or not the property goes through probate. For example, even though funds in an IRA pass by virtue of a beneficiary designation, the funds are still potentially subject to estate tax. As with the gift tax, there are exemptions to the estate tax. For example, property that you leave to your spouse will generally not be subject to estate tax because there is a full deduction allowed for marital transfers. A similar deduction is available for property left to a charity. In addition, as discussed on the previous slide, each individual has a lifetime exclusion from gifts and estate tax combined. To be clear, that limit exclusion that covers both gifts and estates. So any portion of the exclusion you use for gifts will not be available for your estate. There is a new feature of the lifetime exclusion that is potentially very important to married couples. The exclusion is portable. That means that any portion of the exclusion that is not used by a deceased spouse can be transferred to the surviving spouse. In prior years, that was not the case. So married couples with large estates had to do what's referred to as a bypass planning, typically using a trust. But for 2011 and later years, such planning will not be necessary to transfer tax purposes, although there are other good reasons to use a bypass trust, but that is more than we want to discuss today. Suffice it to say that together, a married couple can pass along $23,400,000 tax-free for 2021, as long as the estate of the deceased spouse makes the proper election on their estate tax returns. The third piece of the transfer tax system that we need to mention is the generation skipping transfer tax. In the world of estate planning, someone who is more than one generation below you, for example, a grandchild or great grandchild, is referred to as a skip person. If property is transferred either during life or at death to a skip person, then the transfer is subject to generation skip transfer tax, which is imposed in addition to gift tax or estate tax. The reason there's a generation skipping transfer tax is to prevent individuals from avoiding estate tax on the intermediate, the skipped generation. Because the generation skipping tax transfer is a separate tax, you get a separate exemption. The exemption for generation skip transfer tax purposes is also the same 11,700,000 for 2021. Unlike the gift and estate tax exclusion, the GST tax exemption is not portable. Some key tax figures are adjusted each year for inflation, and you can see how the exclusion and exemption amounts have changed. Tax Cuts and Jobs Act, signed into law in December 2017, doubled the gift and estate tax exclusion amount, and the GST tax exemption to the amounts are, after 2025, they are scheduled to revert to pre-2018 levels and cut by about one half. If your estate is larger than the exclusion or exemption, you may want to do some estate planning to minimize the potential impact of transfer taxes. Making gifts during one's life is a common estate planning strategy that can also serve to minimize transfer taxes. In fact, transferring property to your heirs during your lifetime has certain advantages over waiting till you die. For one thing, when you make lifetime gifts, you have the satisfaction of seeing the recipients enjoy your gifts. For many people, though, gifting is used to minimize transfer taxes. As I mentioned earlier, one way to do this is to take advantage of the annual gift tax exclusion, which lets you give up to $15,000 to as many individuals as you want, gift tax free, and that's the 2021 figure. There are several other gift tax exclusions and deductions that you can take advantage of. In addition, when you gift property that is expected to appreciate in value, you remove the future appreciation from your taxable estate. There is one trade-off to lifetime gifting, though. Generally, if you give property during your life, your basis in the property for federal income tax purposes carried over to the person who received the gift. So if you gave your $1 million home that you purchased for $50,000 to your brother, your $50,000 cost basis carries over to your brother. If he sells the house immediately, income tax will be due on the resulting gain. In contrast, if you leave the property to your heirs at death, they get a stepped up basis on the property equal to the fair market value at the time of your death. So if the home that you purchased for $50,000 is now worth $1 million when you die, your heirs get the property with the basis of $1 million. And if they sell the home for that $1 million, then they don't have any federal income tax gains. Remember that the annual gift tax exclusion lets you give $15,000 to as many individuals as you want, gift tax free in 2021. If you and your spouse make gifts together, you can double that amount and give $30,000 to as many individuals as you want. If you're contributing to a child or grandchild Section 529 plan, a type of tax deferred college savings plan, you can give $75,000 gift tax free. Though you will have to report the gift over a period of 5 years, if you and your spouse contribute together, this amount is $150,000. Certain conditions apply in each case, but be aware that if you should die during the 5-year period, a pro rata share of the gift will be included in your estate for estate tax purposes. Also be aware that the $15,000 figure is indexed for inflation, so this amount may rise or fall in future years. In addition, there is no gift tax imposed on any amounts paid directly to an educational institution for an individual's tuition. There's also no gift tax imposed on any amounts paid directly to a medical care provider for an individual's medical care, including payments for health insurance premiums. If you are not inclined to make outright gifts, you might consider using a trust. A trust is a common and versatile estate planning tool. We've already seen that a trust can play a role in planning for incapacity and in avoiding probate. In addition, you may want to use a trust as a part of an overall strategy to minimize transfer taxes, to have certain property managed by a professional, and to provide for minor children, elderly parents, and other beneficiaries. And certain trusts can be established to protect your assets from future creditors. Most importantly, though, trusts can provide a means to administer property on an ongoing basis according to your wishes, allowing you to maintain a degree of control after property is placed in the trust, even after your death. A trust is a legal entity where someone who's called the grantor arranges with another person who's called the trustee to hold property for the benefit of a third party who's called the beneficiary. The grantor names the beneficiary and trustee and establishes the rules the trustee must follow in a document known as the trust agreement. When you create a trust, you split the ownership of the trust property. Legal ownership goes to the trustee and beneficial ownership goes to the beneficiary. That means that the trustee is legally responsible for managing the property according to the trust rules, and that the beneficiary receives the financial benefits such as income, principal, and use of and enjoyment from the trust property. A trust that you create while you're alive is referred to as a living or inter vivos trust. A trust that is created upon your death, for example, under the terms of your will, is referred to as a testamentary trust. If you have the right to change and or the trust end the trust anytime you want to, the trust is described as a revocable trust. If the trust cannot be changed or revoked, the trust is described as an irrevocable trust. A revocable trust generally becomes irrevocable when you die, since you're no longer around to change or revoke it. And while we won't go into great detail, revocable trusts are commonly used to plan for incapacity and avoid probate. A trust avoids probate because the trust agreement itself determines what happens to the trust property upon your death. Irrevocable trusts, on the other hand, are commonly used for transfer tax planning and creditor protection. Life insurance plays a part in almost everyone's estate plan in one way or another. For example, if you otherwise have a small or modest estate, life insurance can be used to actually create an estate. In other words, the life insurance proceeds will be the primary financial resource for your surviving family members, at least until they are able to access other financial resources. Life insurance can also be used to provide liquidity for your estate. That is, the life insurance proceeds will provide the cash your survivors need to pay final expenses, outstanding debts, and taxes. For example, you may have physical assets such as a home, a retirement plan, and some investments that you do not want to be liquidated, but rather left intact for your surviving spouse. And life insurance can play many other roles as well, such as creating a bequest to a charity or providing funds for your children's college education. You need to be aware, however, that the general rule is that life insurance proceeds will be included in your estate for estate tax purposes. Now, recall that in the beginning of this presentation, it was made clear that we're only talking about taxes on the federal level, and the situation may be different on the state level. A common strategy to avoid estate tax on life insurance uses a trust to own and hold the life insurance policy. Such a trust is commonly referred to as an irrevocable life insurance trust or ILIT. If the ILIT owns the life insurance policy, the proceeds of the policy will not be included in your estate or for estate tax purposes. However, this is only true if the strategy is correctly implemented. Ultimately, you'll need to work with an experienced estate planning attorney if the strategy is of interest to you. But let me give you a basic idea of how an ILIT can work. You create an irrevocable trust, name someone as trustee, and name beneficiaries. The trust buys a new life insurance policy on your life, and it owns the policy. You make cash gifts to the trust. The trustee notifies the beneficiaries as you make the cash gifts, and the beneficiaries have a limited window of time during which they have a technical right to withdraw your cash gift, but they don't, since withdrawing the gift would defeat the purpose of the trust. As the withdrawal period elapses, the trustees use the cash gifts to pay the premiums on the policy to the insurance company. At your death, the trust receives the proceeds of the life insurance policies. If properly implemented, no estate tax is due on the life insurance proceeds, and the funds are distributed according to the terms of the trust. And the beneficiaries of the ILIT receive funds free from estate tax. Like most trusts, irrevocable life insurance trusts are a more advanced estate planning strategy, and I've just attempted to give you a very basic understanding of how they might apply in your situation. If you are interested in learning more, be happy to provide you with additional information. As we wrap up, take a moment and ask yourself these questions. Do you have a plan in place for incapacity? Do you have a will? If the answer to either question is no, there's really no time to waste. You need to address these issues as soon as possible. Ask yourself as well if transfer taxes are an issue for you. If you died today, would your total estate, including your home and life insurance, exceed the federal exclusion or your state exempt limit, which may be less? And finally, even if you have an estate plan, does it reflect your current wishes and circumstances? Small steps can enhance your financial life one day at a time.